As a property owner, it is difficult to deal with tenants who refuse to pay rent or violate the terms of their lease agreement. In California, there are specific procedures you must follow in order to legally remove a tenant from your property. In this video, I will provide you with a step-by-step guide on how to do an eviction in California. A landlord cannot turn off power or other utilities, lock a tenant out, or throw out their belongings to get the tenant to move out. If they do, the landlord can be in big trouble. I am not a lawyer, and this is not legal advice. It is always recommended to hire a lawyer to ensure you comply with state and local laws and regulations. Step 1, provide a proper notice. This first step in the eviction process is to provide the tenant with proper notice. This notice must be in writing and should state the reason of the eviction. If the eviction is due to non-payment for rent, you must give the tenant a 3-day notice to quit or pay. If the eviction is due to a violation of the lease term agreements, you must give the tenant a 3-day notice to comply or quit. If the tenant fails to comply with the notice, when the specified time frame, you can proceed with the eviction. If the eviction is for anything else, the notice will probably be a longer time frame. Depending on the situation, it could be anywhere between 30 to 90 days. You must make sure to have a copy of the written proof and pictures, if possible, that the tenant was served the notice. Make sure the form you're using for your notice includes everything that is required by the California law. If there are mistakes or missing information in the notice, you may lose the case and have to start the case all over. I suggest using a property manager or an attorney for your forms. And remember, if you're not exempt from AB 1482, there may be different steps. Please like, subscribe, and share. Step 2, file an unlawful detainer lawsuit. If the tenant does not comply with the notice, the next step is to file an unlawful detainer lawsuit. This is a legal action that you must take in order to regain possession of your property. You may need legal help with this. Evictions are very detail-oriented. You can lose your case even if you only make a small mistake, like counting the days wrong or getting the amount of past due rent. If you lose, you have to start all over. File the lawsuit in the county where the property is located. Once the lawsuit is filed, the tenant will be served with a summons and a copy of the complaint. Make sure to list all tenants and any other people who live in the home that are over 18 as defendants, even if their name is not on the lease. If there's more than one tenant, they can all be evicted with one set of forms. If anyone residing in the home over 18 is not listed, then they may not be included in the suit and do not have to leave. You would then have to evict them separately. Gather the papers you need to attach to the court forms, a copy of leases or rental agreements, and any written changes that the tenant agreed to, a copy of the notice that you gave the tenant, and written proof that the tenant was served the notice. Anything else that will help provide the judge that your tenant should move out. Step 3 would be to attend the court hearing. After the tenant has been served with the lawsuit and the court hearing will be scheduled, you will need to attend a hearing and present your case to the judge. If you have evidence, things like photos, emails, and papers that will help to prove your case, bring those with you and make sure you make several copies. The judge, the tenant, their attorney, and yourself all need a copy. If the judge rules in your favor, a writ of possession will be issued, which allows you to legally take possession of the property. However, if the judge rules in the favor of the tenant, you will need to start the eviction process all over again. Step 4, arrange for the sheriff to evict the tenant. Do not try to do this on your own. Once you have obtained the writ of possession, you can arrange for the sheriff to evict the tenant. You should contact the sheriff's office directly to see what their process is, as each office might be slightly different. The sheriff will post a notice on the property informing the tenant that they must vacate the premise within a certain time frame, normally 5 days. If the tenant fails to leave, the sheriff will physically remove them from the property. You should have a locksmith there to change the locks. Step 5, collecting any outstanding debts. After the tenant has been evicted, you can take steps to collect the outstanding debts, such as unpaid rents or damages to the property. You can file a small claims lawsuit against the tenant to recover these debts. However, you should be aware that collecting debts can be a difficult process, especially if the tenant has limited financial resources. Evictions can be a complex and time-consuming process, and it is important to follow the proper procedures to ensure that you are acting within the bounds of the law. If you are facing a difficult eviction situation, you may want to consider seeking advice from an expert attorney who can guide you through the process and help you achieve a successful outcome. As a property manager, I would serve initial 3-day notices or 30 to 90-day notices. If the tenant does not comply, I then refer the case to my attorney to make sure the process is done correctly. I only want to do it once. Thank you for watching. I'm Dominique Vescuso from Your Home Imagined.